I am going over all of the judge's rulings with regards to the Idaho 4 Moscow murders motion in limine hearing that happened on April 9th. He posted a list of all the things that he pretty much ruled on the spot in court, but also a bunch of new filings for the things that he kind of was like, I'll give you a decision soon. So right now I'm going through, this is part 2 of the document listing all the things that he pretty much already ruled on, just to give a kind of overview and his reasonings behind it, as well as I'm going to move into the new things that were posted today. So this is a short paragraph, so I'm just going to read it. Defendant moves in limine to exclude any misleading comments about the meaning of likelihood ratio for DNA purposes. Specifically, defendant seeks to avoid attempts to define likelihood ratio through a comparison to the world population. The state agrees that this type of comparison is inappropriate. The court grants defendant's motion insofar as it applies to the question asked by the prosecutor at the grand jury proceedings, which both sides agree was not proper. However, the court will not dictate how the question is to be asked at trial. If defendant believes there is a similar misrepresentation as to the likelihood ratio at trial, he can object at that time. Now, this is defendant's motion regarding inconclusive data from the finger clippings that were taken from Madison Mogen. The defendant moves to limit expert testimony about the Idaho State Police Forensic Lab statistical analysis of a swab taken from the finger clippings of Madison Mogen, item Q13.1. The testing revealed a likelihood ratio in the inconclusive range as to whether the defendant was a potential contributor to the DNA mixture. During her grand jury testimony, the lab analyst, Jade Miller, testified that inconclusive meant she was unable to say one way or the other if the defendant is included in the mixture. Defendant argues this is a misleading language in that it allows for an inference that defendant might be included, which he asserts is inaccurate. The state indicates it will not offer the results of the Q13.1 as inculpatory evidence, which defendant agrees renders his motion moot. However, if the state changes course with regard to the evidence, it must first raise the matter with the court outside the presence of the jury so the anticipated testimony regarding the meaning of inconclusive can be discussed. At this time, however, the motion is denied as moot. So now this is regarding the defendant's motion for excluding Amazon click activity at trial. Defendant moves to exclude any evidence of defendant's Amazon purchase history or click activity on grounds that it is out of context, incomplete, and unfairly prejudicial. This evidence will be presented by the state through Shane Cox and Michael Douglas, who will testify simply to what the documentary evidence state, all of which was provided to defendant in discovery. The evidence is highly relevant. A K-bar knife sheath was found lying next to the body of one of the deceased victims, all of whom were stabbed to death. Defendant's DNA was found on the knife sheath. Records from an Amazon account registered to defendant's name and email show that a purchase of a K-bar knife and sheath was made from the account approximately 8 months prior to the homicides. Click activity on the same account shows the customer also viewed pages associated with K-bar style knives at that time, and in the week following the purchase, viewed pages associated with the shipping progress of the knife and sheath. The product was shipped to bryankohberger at his family address in Pennsylvania. After the homicide, activity from the same account showed the user navigated pages related to the deletion of account activity, and a week later viewed pages associated with the K-bar knife and sheath. This evidence establishes a significant connection between defendant and the K-bar knife and sheath. In addition, there is no basis under IRE 403 to exclude the evidence, particularly given how probative it is. Defendant argues it is misleading and prejudicial because it paints an incomplete picture of the account activity. To this end, defendant provides the declaration of his expert, David Howell, the founder of a firm specializing in inter alia, digital forensics, and digital marketplace analytics. According to Mr. Howell, far more information must be reviewed in order to attribute specific activity to a specific person or otherwise render an opinion about a user behavior within forensic certainty, including Amazon advertising logs, recommended algorithms, cross-device history, retargeting behavior, account personalization, and device IDs. He says defendant is free to challenge this evidence through cross-examination and establish that Mr. Howell, while more information is needed to reach the conclusion that defendant made the purchases or clicks, however, it is not a basis for exclusion. There is nothing inherently unfairly prejudicial or misleading about the evidence itself. It will be up to a jury to consider all the evidence and decide whether defendant was the clicker. Thus, the motion is denied. Now this is regarding the state's motion for AT&T timing advance records. The state moves in limine to prohibit the defense from making any reference to the absence of AT&T timing advance records related to defendant's cell phone. The state contends it never received such records from AT&T in response to its subpoenas, and therefore any statements by defendant that the records could have or should have been provided to defendant should not be allowed, as it mischaracterizes the evidence, will mislead the jury, waste time, and cause undue delay. In support, the state provides certificates of authenticity AT&T for each of the two warrants, stating that it did not provide the timing advance records for phone number 509-592-8548 or 58, because such records were at the time only available if requested within 7 days of a specified time frame. Defendant, relying largely on the affidavit of its expert Cy Ray, is adamant that the state did receive the documents, which he argues are exculpatory, and is hiding them. Defendant points out that he has a constitutional right to challenge evidence against him, and therefore must be allowed to explore the state's misrepresentation as to the availability of the records. The 6th and 14th Amendments guarantee a criminal defendant a meaningful opportunity to present a complete defense. This includes the right to confront and effectively cross-examine witnesses. However, these rights are not absolute. The trial court may reasonably limit cross-examination that is harassing, confusing, repetitive, or only marginally relevant. The Confrontation Clause guarantees an opportunity for effective cross-examination, not cross-examination that is effective in whatever way to whatever extent the defense might wish. Additionally, a defendant has no right to present irrelevant evidence, and even if evidence is relevant, it may be excluded in certain cases. Applying the principles here, defendant will be allowed to voir dire special agent Balance outside the presence of the jury to ask whether he received the timing advance records covering the early morning hours of November 13th, 2022, and the months prior, when defendant was believed to have been in the area of the 1122 King Road. However, if agent Balance denies having received the records, defendant may not explore the matter further, either in voir dire or before the jury, given the absolute lack of any factual basis supporting his position that the state is hiding them. Thus, the state's motion is granted, except as qualified regarding the very brief voir dire outside the presence of the jury. He's scared of Cy Ray. Now this is regarding the state's motion for self-authentication of records in reliance to IRE 8036, 8038, 9024, 11, and IRE 80324. Now the state wants to permit the admission of approximately 60 exhibits. So the court says however, the state acknowledges IRE 90211 contains a notice requirement that has not been satisfied. To this end, the court will require that after proper notice is given to the IRE 90211, the parties are to meet and confer regarding self-authentication and any objections defendant may have to specific exhibits prior to raising the issue with the court. The court's ruling on this motion is reserved. So that's part 2, and there's 2 more in this particular document regarding the alibi and the demonstrative evidence, the one that they wanted to do and not to scale build out of the 1122 home. I'm going to reserve those for my next video, so make sure you watch the previous one and this one, and then we're going to get on to the next 2.